A few years ago, I represented a client, Maria, in her successful divorce claim for spousal maintenance. Maria and Carson had been married for 20 years, having relied most of that time on his primary income as an architect. Maria had taken a sales job in recent years and had demonstrated herself as quite skilled in that competitive industry. Nonetheless, she was solely dependent upon commissions for her income. The divorce had ended badly. Carson had moved out for several months under the guise of visiting his mother in Texas while working remotely. However, when he came back, Maria had reason to not let him in the house. It went downhill from there. Some people think that addressing divorces without custody disputes are easier. However, if there's a significant imbalance amongst their incomes, as there was here, they oftentimes reveal themselves to be just as complicated. First of all, Maria couldn't afford to pay all of the bills without his financial assistance. Secondly, even if she were able to reduce her overhead so that she could pay for everything, Maria shouldn't have to. She had spent years supporting the development of Carson's career and ability to demand larger incomes. Maria did this to the sacrifice of developing a career of her own. Under Minnesota law, my client could be said to have contributed to the overall ability of their marriage to earn the greater income seen in their last 3 years' tax returns. We worked with Carson's attorney and him to exchange all relevant financial documentation. More importantly, we dug down into Maria's pay stubs, her commission reports, and her bank statements so that we could comprehensively articulate exactly what her historic income had been and what it could arguably be in the future. We were ready for the negotiation at mediation. We also had a plan for her future. Maria knew what kind of life she wanted. We knew what kind of home she wanted to move into. We knew what spousal maintenance she was shooting for, and we also knew what her bottom line was. At mediation, Maria and I were in one room and Carson and his attorney were in another. The mediator went back and forth. Every time the mediator was in the other room, he spent 20 minutes there. During that time, Maria and I were comparing notes against our game plan. We had an estimate each time as to how much money per month, and the total number of months, Carson was going to respond with. The mediator would come back into our room, give us Carson's counter, which was remarkably comparable to what we had projected, and we were able to send him back after spending merely 5 minutes with us. Within 75 minutes, we reached an agreement on spousal maintenance, one where Maria got more than her "I'll be happy if I can get X amount," and one that gave her post-divorce support until she retired. There is no formula for spousal maintenance. It is as much art as science. The statute merely provides factors to be taken into account. When there isn't a legal code or a formula under law, how an issue gets negotiated is likely to be the difference between a good and a bad outcome. If an attorney doesn't have a clear plan as to what they're doing and how they're going to accomplish their client's goals, those goals are not to be reached. This is what we love to do for our clients. We love to take all the facts, organize them with a clear strategy, with clear contingencies, so that no matter where the argument goes, we're ready for the next step. This allows clients and us to secure an agreement to lock in the successful accomplishment of our client's goals. Atticus Family Law. This is where things get better. Guaranteed.